Hello, this is KL Morgan on video. I just wanted to let the clerk know that I am available if anyone needs the ASL interpreter. There.
Can you identify yourself for the record?
Absolutely, Your Honor. KLKAYELLE.
Be reviewed in the petition with your attorney, and I'll just go over those again with you for the record. So are you aware that when you enter a plea, you give up the right to make the district attorney bring all the witnesses, all the evidence to trial, and to prove these charges against you beyond a reasonable doubt?
Yes, I am.
And that you're giving up the right to have your attorney help you by presenting any defenses that might apply and making arguments to the jury they should find you not guilty?
Yes.
And that you're giving up the right to have a jury listen to the evidence, listen to arguments and defenses, and they would have to make a unanimous decision in order for you to be found guilty?
Yes.
And you are also giving up the right to have your attorneys challenge evidence by filing any legal motions that might apply or making objections to evidence at trial. Did you understand that?
I do understand that.
And also, are you aware that you're giving up the right to have your attorney cross-examine and challenge witnesses who testify against you?
Yes.
If you wanted to bring witnesses of your own to court, you could do that by getting the judge to issue a subpoena to order those witnesses to court, but you're giving up that right. Is that your understanding?
I do understand.
You're also giving up the right to take the stand and testify and tell your side of the story in your own defense.
Yes, I understand.
If you did not want to testify, you don't have to, and the judge instructs the jury that they cannot use your silence as evidence against you. So are you aware that you give up the right to have the judge give that instruction if you wanted to remain silent at trial?
I'm aware.
But since you're entering a plea today, you're giving up that right, and I can ask you questions about your case. The endangering in an aircraft in the first degree charge is a Class C felony that carries a maximum sentence of 5 years in custody and $125,000 in fines. And each of the recklessly endangering another person charges are Class A misdemeanors and carry a maximum sentence, each of 364 days in jail and says here $5,000 in fines. Are you aware that's the maximum penalty that you face?
Yes, I am.
And are you aware that if you are not a U.S. citizen, this plea could be used as grounds to deport you, deny your application for naturalization, or exclude you from future admission to the United States?
Yes, I'm aware.
And that if you were on post-probation parole or post-prison supervision for anything, this could be used as grounds to violate your supervision, and you could get jail time in addition to any jail time that you face here.
Yes, I'm aware.
And you will be required to provide a blood or buccal sample that will be kept on record for the state for DNA.
Okay, yes.
And I don't think there are any charges being dismissed, right?
Correct, Your Honor.
There is a joint agreement. You've entered into negotiations with the state, and that involves pleading or stipulating to a grid block of 8I, and this is the sentencing guidelines that apply in Oregon, and there's a presumptive prison sentence in the 8I grid block of 16 to 18 months. Did you understand that?
Yes.
And however, it's a stipulated downward departure from that presumptive sentence, from that presumptive prison sentence, to 60 months formal probation. So did you understand that?
Yes.
When you're on probation, there are general probation conditions that apply to everybody, and it's by statute, and it includes paying any fines, fees, or restitution as ordered by the court. If ordered, submit to testing for controlled substance use, participate in a substance abuse evaluation and any treatment as directed, participate in any mental health evaluation and treatment as directed, remain in the state of Oregon until written permission to leave is granted. We'll be discussing a little bit of that later. Do not change residence without permission from your supervising officer. Permit the probation officer to visit your work or home to do a walkthrough. It is a condition to consent to the search of your person, vehicle, or premises upon the request of the supervising officer if there is reasonable grounds to believe that evidence of a violation will be found. Also, a condition to submit to fingerprinting or photographing if requested. Obey all laws, so any new criminal violation, but also traffic violation could be used as grounds for a probation violation, and you could get jail time in addition to any jail time that you face here. Promptly and truthfully answer all reasonable inquiries from the supervising officer. Do not possess weapons, firearms, or dangerous animals. Report as required and abide by the direction of your supervising officer, and if ordered, submit to a risk and needs assessment as directed by your supervising officer. Did you understand those general conditions?
Yes.
And there are some special conditions that include a jail sentence, 50 days of jail with credit for time served. Community service, 664 hours, which I understand to represent 8 hours for each of the passengers, and to be done at a minimum of 12 hours per month. Restitution, you're stipulating to causation and liability for restitution. Do these amounts reflect a final amount?
Your Honor, we're going to be asking to keep restitution open for 90 days past entry of judgment in the event another victim wishes to pursue restitution.
Okay. We can do that. In the meantime, the restitution that is already known is $59,608.25 to Alaska Air Group, $573 to Yvonne Millam, $387.88 to Anthony Wang. Did you understand those special conditions?
I do.
It's possible, potential that more restitution may be coming within the next 90 days. And if so, you are stipulating to causation and liability for that restitution in an amount to be ordered by the court. And you have a right to be present in court at any time the judge, the court signs a restitution order. You can talk to your attorney about, if that does happen, about whether you want to be present for that or whether you want to waive your presence for that. And if there is a restitution hearing, part of your plea agreement is that you agree to the admissibility of any written estimate from a business or victim as evidence of a damage amount, and that any witnesses can appear by video or telephone at a restitution hearing. And you are also agreeing that any money seized or bail posted can be applied to the restitution in this case. Did you understand all of those conditions?
I do.
Okay. Those are general conditions. There are some specific conditions that are checked off here that are already general conditions. It's also a condition that you not have any contact with any victims or witnesses in the police report, except any letter or statement of apology per your PO. You are stipulating to the relinquishment and forfeiture of any seized property that's listed as evidence. Is that applicable here? Other than bail amount?
Your Honor, I don't actually think that that's going to apply to anything else. We haven't discussed anything except a cell phone, which I don't believe is in the custody of the Port of Portland Police Department. So, other than that, I don't anticipate there being any property issues.
So you are also agreeing that the probation officer can impose and require any of the conditions that we already discussed are the special conditions, and that there may be additional conditions, even if not specifically listed in the pretrial offer agreement of the parties. And so condition that that the probation condition to obey all laws includes the requirement that you obey any court orders regarding probation conditions in other cases. So I don't believe this applies to you, but if you were on supervision in another jurisdiction and a judge ordered you to do something in that case, that would apply in this case as well. If you, the state, there were any future probation violation hearing, that you can appear by video or telephone. And probation will come back to me as the probation judge, any of those hearings. No entry into or within 25 feet of an operable airplane or multi-passenger aircraft without written PO approval. No use or possession of controlled substances except pursuant to a medical prescription, and comply with any and all supervisory orders as listed in United States versus Joseph David Emerson, case number 323 MJ 00185. Did you understand all of those special conditions?
I do.
If you fail to follow any one of that list of conditions, there can be a probation violation warrant. You can be arrested on that warrant, held in jail until a hearing, at which time a judge will decide whether you're in violation of your probation. So did you understand that's a consequence?
I do.
If you're revoked on the probation, well, first of all, at that other hearing, you can get additional jail time in addition to any time that you were already held pending the hearing. Did you understand that?
Yes.
If you are revoked on your probation, that is when you could be sentenced on count 1 to this 8I grid block, 16 to 18 months in prison with 3 years post-prison supervision. On the misdemeanors, you could be sentenced, if revoked, to the maximum sentence of 364 days in jail. And because of the number of victims, that could run consecutively. Did you understand that?